Good morning. So today we have a guest speaker. We have with us John McNett. John is actually an adjunct professor in mechanical engineering and has been working with ME for a long time as an adjunct professor. This is his second term, which just got renewed. John has been very instrumental in developing a new intellectual property class, which I would recommend all of you on campus to definitely take. It's a one-credit class, so it really can fit in your gaps and adds a lot of value to your education at Purdue. A little bit about John. John got his undergrad degree from Purdue and a law degree from George Washington University. He has been working on a lot of patent matters and is one of the best-known attorneys in the U.S. He has also worked quite extensively in the patent office itself and has done some interesting things there. In general, his early career, he handled U.S. and foreign patents, especially for the Gatorade thirst quencher. All of you know the Gatorade, so that's something that John has worked hands-on. He has also worked as a director for a biotech company in San Francisco and been a lead trial attorney for Thomson Consumer Electronics on patent litigation involving satellite television, and also for the Riley Industries in patent litigation involving polyvinyl pyridine. Okay, I got that almost right. He has conducted jury trials for a number of cases, and also in the U.S. Supreme Court case of Christensen versus Colt Industries. That's a very famous, well-known one, and also the trade secrets resulting in the M16 assault rifle. He's frequently, in my opinion, he's ranked in the top 1% in the country. I've sort of changed his own ranking there, and we welcome John. John, thanks for coming, and we look forward to your lecture.
Okay.
Your tie goes with your earlier Purdue degree as well.
Yes, it does. I have a periodic table tie in case anybody needs atomic weights or numbers. That's right here on my tie. The goal today is to talk about understanding patents and eventually how an understanding of patents actually can improve your product design. But first off, we're going to go through a couple of the fundamentals of patents and have quite a bit of material to cover. The essence of patents is basically the right to exclude others or to obtain payment from others for using an invention that an individual has come up with or a group of individuals has come up with. One of the things that people continually misunderstand is that they think if they get a patent, they are then entitled to make products or do something. Getting a patent does not in any way affect your right to do something, other than to exclude other people from doing things. It's an exclusionary right. It's not a positive right that says what you can do. It's a right that you own that says what other people cannot do unless they pay you money or unless you give them permission. So that's the first thing to remember about patents, is it's an exclusionary right that tells other people what they cannot do. It's not a right that says what you can do. It's a right that's granted by the government, and it impacts a person's ability to freely make, use, sell, or offer for sale or import an invention of another. Any one of those items, making, using, selling, offering for sale, or importing, is a right that is affected by this exclusionary power that you have if you get a patent, or that impacts you if somebody else has a patent and you're trying to do one of these things. There are basically three types of patents. Usually when you think about patents, you are thinking about what's called a utility patent. And utility patents address the functional aspects of inventions. Examples would be Edison's light bulb or the Wright brothers' airplane. Utility patents only encompass the functional aspects. They don't encompass non-functional or aesthetic aspects. If you want patent coverage for non-functional aspects, you get what's called a design patent. Design patents only cover the appearance of something. The example that we give on the PowerPoint is a novel aesthetic shape of a television remote control, the curvature of it. The moment that you realize that part of that shape is specially made to functionally fit your hand, you can't then get design patent coverage as to that aspect of the design. It's only on the aesthetic attributes that make it look pretty or pleasing, but not on any aspect that is functional. So the two different kinds of patents are polar opposites in what they cover. The one covers functional and the other covers the aesthetic aspects. And there's a third category of patents that we're putting in here for completeness, and that's for plants that are reproduced asexually. Typically, roses and apples and the like are covered by plant patents if someone comes up with a new variety of patents. There are basically three questions that we're going to address today. First is, what do I do if I have an invention? Second, what do I do if others have patents that might cover what I want to do? And third, can my product designs be improved in an innovative way if I better understand how to define inventions? And this last category is the premise, essentially, of the course that I teach in the fall, ME554, that goes into much greater detail on defining inventions, with the thought that if you really know how to define inventions and how to think about inventions, you will become more innovative in your engineering projects. What do I do if I have an invention? The first thing you should do, almost always, is to do a thorough search of the prior art. It's almost always critical to the process, and it is a step that is oftentimes short-shrifted. Many people think, I've got this great idea, let me just get a patent on it. The first thing you need to do is to do a search. You need to know what is the closest alternative to what it is that you've come up with, and you need to be sure that, in fact, nobody else has come up with it earlier, because if they have, then the process ends. But to the extent you have something different than anybody has done before, and you know exactly what it is that people have done before, you then can make good comparisons. And then once you can make those comparisons, you can then turn to the task of writing a definition of your invention that avoids that prior art, but encompasses what you've done. And once you've got that definition, you can look at that definition to see whether or not the coverage you'd get with that definition is worth the process of spending money getting a patent. When we talk about prior art, we're considering that everything that people have done before that is legally permissible to be used as evidence against a claim of novelty or patentability of a later invention. And it differs by country. Different laws in different countries make different things prior art. But for the most part, anything done before you invented your invention is prior art. And any publication, as to the U.S., more than a year before you file for the patent, or any offer for sale before you file for a patent, even if it's not public, more than a year before you file, is prior art in the U.S. In foreign countries, then the standard is different. Anything prior to filing that is public is prior art. In order to do your search, which is so critical, most inventions lend themselves to being searched most efficiently by looking at the patent database. That's much more effective because the patent database is really detailed, it's exhaustive for the most part, and it has dates that are clearly shown on the document. So you know what date a patent issued, you know what date a patent was filed, and so most things are searched best, at least the first go-around, on the Patent Office database. There are plenty of places you can find that. The Patent Office itself has a database. Google has a google.com/patents database, and there are some commercial alternatives as well. If you want to print copies, there are several sites that are very efficient for printing copies of patents as well on paper. Other resources is just doing a straight Google search, not using Google Patents, but just Googling. But you find things on Google, you don't know what the date is. You don't know whether it was a month ago or a year ago. And so once you find it on Google and you find the website, then you can use the Wayback Machine on archive.org to date that web entry. Basically, archive.org takes snapshots of everything on the web every so often and dates it, so you can go back and find when something was on the web, and you've then got that date to establish as prior art. That's very handy, particularly if you're trying to show someone else's patent is invalid and your evidence is something that's on the web. Archive.org will let you establish that date on the web. To obtain patent rights, you typically spend around $10,000. Additional costs and fees throughout the 20-year term might add another $15,000. They have something called a provisional patent application, which is a little bit lower cost, but you have to file a regular application within a year, and so it's a toss-up whether it's worth saving a little bit of money at the beginning to then have to pay the same amount of money again within a year to get a regular patent application. There's a wide variation in the quality and price of patent applications. Typically, the quality is paramount for patents because patents basically give you exclusionary rights over the entire United States and territories if you file in the U.S., and that's generally worth a whole lot more money than you spend getting a patent if the invention turns out to be worthwhile. And if you don't do the job right in getting a good patent, the patent oftentimes is not enforceable, its coverage is limited and can be easily designed around, or it might be invalid. So quality tends to be very important when you're trying to get an exclusionary right for all commerce in the territory covered by the patent. The cost to enforce rights in the United States is very expensive, often in the millions of dollars, but that is a reflection of the fact that patents are oftentimes very valuable, where there are tens of millions or hundreds of millions or sometimes more at stake. And so the cost is relative to what's of value. There are administrative challenges to validity through a reexamination in the patent office. If someone gets a patent and you think they shouldn't have gotten it, for much less money than a lawsuit, you can file a request to have the patent office reexamine that patent application if you have some prior art that is a public publication or an earlier issued patent that you think should have prevented the issuance of the patent. They will reconsider the decision, and they may cancel the claims in the patent if you are correct. With regard to rights outside of the United States, you might spend an additional $5,000 per country, except about $10,000 each for Europe and Japan, with additional maintenance fees every year in each country. So that if you're really trying to get worldwide coverage of an invention, it can be very expensive because there are a lot of countries in the world, and if you start spending $5,000 per country, it adds up to quite a bit of money. And then if you have to pay annual fees every year to maintain the patents enforced during the 20-year term of the patent, that really can be quite expensive. It's generally less expensive to enforce rights in foreign countries than it is in the U.S. And there are generally comparable administrative challenges in foreign countries as well that are reasonably inexpensive if you want to have reexaminations there. Now, if you remember only two things from today, it is the first two items on this slide, because this is where people oftentimes get hung up. The thing you have to remember about patents is that you have to follow the rules to get your patent rights. And if you screw up, you have oftentimes irretrievably lost the right to get a patent. The first one, for the United States, you have to apply for the patent within 1 year of the first offer for sale or description in a printed publication. And those two things are the things that oftentimes trip people up. They don't file for a patent application quickly enough. And if you wait beyond that 1 year period, you're not entitled to get a patent in the United States. The standards are even more rigorous for foreign patents. And in order to get patent rights in foreign countries, you have to at least apply in the United States before any non-confidential disclosure anywhere in the world. If you come up with your invention and you run out in your front yard and say, "Eureka, my invention is," and the neighbors are listening, in theory, you've lost your right to get foreign patent coverage. So that can happen very easily and very quickly, and it's something you don't even really think about. Now, so long as your disclosures to your neighbors are in confidence, and they say, "I'll keep it quiet, don't worry about it," great. It can even be an oral agreement. But it has to be a non-confidential thing in order to lose your rights. As long as you have a confidential disclosure with other people, you don't jeopardize your foreign rights. So that's very important, and particularly startup entrepreneurial companies, that they enter into confidentiality agreements. They don't have to be formal agreements, but there has to be some understanding of confidentiality, and it's ideal if you document it with an email or a letter that this is going to be kept confidential at least until you get your patent application on file in the U.S. Okay, that was the one major thing that everybody will need to know in later life. Another thing that a lot of people don't understand is that patents by themselves are not nearly as valuable as when they are combined with a product or a business that they relate to. A lot of people think, I've come up with this great idea, all I have to do is get a patent, and then I can take that patent and license it, and that's how I'm going to make my money. I don't want to get my hands dirty in business or anything else. But the realities are that industry does not value patents that don't have a product associated with them near as much as they value patents that are linked to a product that has proven itself in the marketplace. And so if you really want to optimize value, you will not only get a patent, but you'll also have a product that has at least some market success when you try to cash out your position in your invention. And for some people, in some situations, you're not really trying to license your patent. You're not really trying to get a product into the marketplace. You already have a product in the marketplace. But the reason why you get patents is to use it if your competitor is going to sue you under their patents. If you have some offsetting patents yourself, then the patent is valuable in that respect. Not that you're really trying to maximize your own patents by licensing them, but just having them there in your arsenal when the other side threatens you under their patents. If you can threaten them back, then maybe both sides will just sort of let each other be, or you'll have a cross-license where neither one really has to do too much. So that's sometimes you get a patent for a defensive reason, not for an offensive reason. Now, one area where almost everybody is confused about patents is in how you value patents. It is very easy to value a patent correctly, but almost nobody does it because they don't appreciate the reason why patents have particular values. And so most people get it wrong. When you're designing a product, it's really important to know what value you're going to have in the patent that is associated with the product you're designing, or what value other people may have in their patents that might be asserted against your product, if it turns out that you might also infringe one of their patents in addition to getting a patent of your own. you have to consider the cost of a license or the potential revenue from a license when you're valuing a particular design. And here's the formula. The value of a patent is a function of how much more profit it can provide compared to other alternatives not covered by the patent. Real simple. The rule of thumb is that the value of a patent to an inventor is about 1/3 of the increase in profit the invention provides, with the manufacturer who actually produces the patented product being entitled to the remaining 2/3 of the increase in profit from the profit you would have had without the patent. That's just sort of how it works out in the real world. So you can go through sort of a checklist, how to value a patent. The first thing that you do is to find the closest, most effective alternative design that does not require a license. And this is part of what you learn when you do the search, which I said is really important first thing to do a very good search. Once you've done the search, you can then make comparisons between the invention that you've come up with and the invention that somebody else might choose as an alternative to your invention if they don't get a license from you. Then you compare the economic differences. If it turns out that your invention costs more and doesn't work as well, the value is 0. You only are going to have a patent that is worth something if what it is that is covered is going to provide an economic advantage as to all other alternatives. Otherwise, people will just use the alternatives. The economic system works really well in that regard. And then if there is a positive difference, then you divide by 3, and that's the value that you need to translate to a royalty. Now, there are four items on this list at the bottom that allow you to sort of fudge for special reasons. Sometimes a patent, even though you think it's good, you recognize there's a special problem on invalidity or unenforceability. There's this really close piece of prior art that you're not sure that your patent is going to be patentable over, or there's something that you've done that might jeopardize enforceability, and so you might have to adjust the royalty downward. If you're going to be granting an exclusive license, you would adjust the royalty upward because the exclusive licensee is the only person you're able to license if it's exclusive, and so you're forfeiting all the other opportunities, so you need to get more. And the exclusive licensee then has a benefit as well, and so he can afford to pay more if he's not having to worry about competitors out there using the same invention as he's paying for an exclusive right. Certain industries have a depressing or an enhancing effect on royalties. Particularly the automotive industry tends to depress the royalty rates a bit based upon its industry practice, a little bit in the consumer electronics business. You have a little bit of the inverse situation in the pharmaceutical field, where royalties tend to be a little bit higher than you might otherwise calculate. But pretty much the 1/3 rule is a good starting point. And then you need to adjust based upon a special need to do a deal. If it happens that they're about to foreclose on your house and repossess your car, you may be willing to do a deal at a lower rate just to get some cash quickly so that you can fend off the creditors. On the other hand, if you're independently wealthy, you might wait. And maybe the company that you're trying to license under the patent really needs this patent so it can differentiate itself from its competitors and then get into particular customers that it couldn't otherwise get into if their products were not distinguished from their competitors' products. So sometimes licensees really need to get a patent so they can have a unique product that opens doors that they couldn't otherwise open. And once you've figured out what this value is, this 1/3 of the enhancement that the patent provides, you then need to convert it to a royalty method. In theory, you could charge royalties based upon the enhanced profitability, but as any good accountant knows, you can make the profitability look like whatever you want if you want to fudge some numbers. It's really hard to fudge gross sales. And so what you tend to do in order to keep people honest is then translate that enhanced profit as a to a percentage of gross sales, and then you agree on the percentage of gross sales, even though it was conceptually determined how much you should get paid by looking at the profit enhancement. You don't write the agreements for licensing based upon profit enhancement. You write the agreement for licensing based upon a percentage of gross sales that would equal what everybody thinks the enhanced profit would be, 1/3 of the enhanced profit flowing from the invention. Typically, it's a percentage of gross sales. Occasionally, the invention is really not a function of the dollar of the dollar sales. It is a function of the number of units that are sold. Some inventions enhance a certain dollar value per unit regardless of what that unit sells for, and so those agreements, minority of the license agreements, are based on a amount of dollars per unit rather than percentage of gross sales. You can use either approach depending on what best reflects where the value lies from the invention. If you do have a dollars per unit, you then would put in a inflation adjustment so that it's the real value of the dollars that sticks with the license over time. Sometimes there are cross-licensing arrangements so that you'll fudge the royalty rate a little bit higher or a little bit lower, going both ways, and it sort of nets out so nobody cares, but as to other people, it looks as though the royalty rates are higher or they're lower, and that can have a beneficial effect depending on the situation in the industry. Some people would rather have it look like their patent is worth more money, so when they sue infringers, they can claim larger damages. And some would rather have cross-licenses at a lower royalty rate so as to provide an example for other people that want to license them as to what typical royalties are. And so they cross-license at below the typical royalty rates. But when you have cross-licensing, you're really free to adjust up and down without it really impacting either party if they're comparably sized parties. Sometimes licenses change the royalty rate with volume and sometimes with time, and it can be either up with time or down with time or up with volume or down with volume based upon the circumstances. Most licenses don't have those variations, but some do. If the license is exclusive, there generally are minimum yearly sales requirements or minimum royalties required in order to maintain the exclusive nature of the license. If you fail to meet those minimums, you either lose the license or you lose exclusivity and it converts to a non-exclusive. The upfront payments or minimum payments per year are only found in exclusive licenses. Non-exclusive licenses rarely have any minimum requirements or upfront payments. Okay, getting an invention to the market is the hardest part. A lot of people think it's really a big deal to come up with an invention. It isn't really hard to come up with an invention, and it isn't really hard to get a patent on that invention. A lot of people come up with a lot of ideas and get patents all the time. The hard part is to getting what it is that you've come up with and you've got a patent on to the market. And that's the reason the patent system exists, to give some protection to incentivize investors to put money and time into an invention to get it to the marketplace to make the world a better place, not just your intellect a better place. One of the things that I repeatedly say, and it surprises people, is not to be overly concerned that somebody will steal your invention. It may be the best thing that could happen to you. The hard part is getting it to market. If somebody stupidly copies your invention that you've made and gotten patented and takes it to the marketplace for you, they're doing you a favor. And they are putting themselves in a very difficult position to defend their actions. Your negotiating position to get a license from them is much enhanced when they've done that. And your burden of getting your product to the market has been eliminated. They've done it for you. Now, sometimes it gets in the way of your efforts to do to market your product yourself, but that will just enhance your case even more against this person. If you can imagine that you bought a lot in a subdivision that's being built out with homes, and somebody comes along and you decide you want to sell your lot. You're just paying taxes on it. It's just sitting there, and there's a lot of other lots in the subdivision that haven't yet been built on, and with the real estate market like it is today, it's not too easy to sell unimproved land. You're trying to sell your lot. What are you going to do? Well, you can see what the comparables are. Somebody down the block sold a similar lot for X dollars, so you think, I ought to be able to get X dollars. But imagine if somebody has been building a house on your lot. You didn't know about it. You didn't give them permission. They built a house on your lot. My guess is that you'll be able to sell that lot for more than anybody else can sell a lot in that neighborhood to that person who's just built a house on it. It's the same kind of thing. Now, what do I do if others have patents that might cover what I do or what I want to do? The easiest thing, and sometimes one of the more beneficial things, is to look at their patent and figure out how to design around their patent. I've seen many cases where somebody is ready to do something and they find a patent where they realize that if they go ahead, they're going to infringe. And so they come up with a design alternative that oftentimes is even better than what they had thought of the first time around. They're sort of forced to come up with an alternative. It eliminates lawsuits. It eliminates licensing. You have a new product that may even be better than what you came up with the first time around. Another thing you can do is take a license or purchase it if they're willing to give you one. And then you go through that valuation calculation of the 1/3 of the value, and you're willing to pay them 1/3 of the enhanced value, and you keep the 2/3 for yourself if you're wanting to do something that might be covered. You'll be better off, and they'll be better off. Another thing that you can do that a lot of people don't think about is to invalidate their patent. Typically, you go out and you try to find prior art that other people have done the same thing that they mistakenly got a patent on. And you say, look, you shouldn't have gotten this patent. I'm not going to pay you a dime. Go away. Here's this publication that was published a year and a half before you filed for your patent that shows the very thing you were trying to cover in your patent. So go away. And oftentimes they do go away if in fact the patent was issued in error. And if they don't agree, you can file a request for reexamination for not a whole lot of money, and the patent office will take care of it and cancel their patent claims. Another thing you can do is simply ignore them. Go ahead with your product. Forget about them. And if it's a really big company who's in a little bit different area and it just so happens that you infringe, but you don't really take away their market share, I've seen cases where nothing happens for the life of the product. Quite often large companies are very ineffective at policing their patents. And they could care less about a little company that's making a modest amount of money that isn't really impacting their market share for their products that they care about. They've got many other things to do with their time than to worry about those things. So depending on the situation, you might even be able just to ignore the patent infringement, keeping in mind that patent infringement is a civil wrong where you may owe somebody money, but it's not a criminal wrong. There's no crime in infringing a patent. It's just a matter of money. And so you can quite legitimately decide, I'm just going to infringe that patent. They're not going to care. Who are they? My little market is not really interfering with their sales, and sometimes that works. Another thing that can happen is if you ignore them and everybody else ignores them, they may sue some other big company who may spend $10 million beating down the patent at no cost to you, and then the court decides the patent's invalid. You win at no cost. And you're in the market, and you've got your product moving along just fine. There are risks to that, because you may end up having to pay damages for infringement, but in the right setting, it's sometimes ideal just to ignore patents. Other times, it's very important not to ignore patents. So you have to pick and choose your time when you do that. Okay. When we're ignoring patents of others, it really matters what industry that you're in. If you are a pharmaceutical company, you really don't want to ever ignore patents of others. It's a very specialized industry. The products are unique. People spend tens of millions of dollars just to get FDA approval for their product, and they will find you, and they will do you in if you're copying their product. If you're an automotive supplier, it's almost the reverse in that setting, because the manufacturers of original equipment automobiles don't like it when their suppliers are threatened. And so if somebody has a patent that they're trying to use to prevent sales to Ford or General Motors, Ford and General Motors aren't happy about that, and they will do what they can to see that the patent dispute is settled so they can buy from the cheapest supplier. And so in that situation, there's much less risk of an infringement problem from a company that is already a supplier of General Motors or Ford or Chrysler or Toyota or Honda or whomever. If you're a little tiny company, you have very little risk of infringement because you're not really impacting the business of somebody with a patent, and patent lawsuits are complex and expensive, and they're not taken lightly. Now, here's the flip side. If you ignore patents of others and you are a willful patent infringer, you have no reason to think that their patent is invalid. You have no reason to think that you don't infringe. You just go right ahead and do it. The infringer can be required to pay 3 times the amount of damages that are assessed with interest, and in exceptional cases, they may have to pay the other's attorney fees. And so the dollar amounts can be rather large if you guess wrong. It's like all business decisions, there are pluses and minuses to whichever path you take. Courts do frequently find that a patent is invalid or that it's not infringed. That's a common outcome, and so there's some comfort in the fact that you have a reasonable shot at escaping liability from patents in many instances. And the last item is, can my product designs be improved in an innovative way if I better understand how to define inventions? By learning fundamentals of defining inventions with various scopes, through exercises both to improve upon recently patented inventions and to design around them, the designer learns approaches to thinking unlike in any other course. This new perspective has the potential for better design skills. Now we're going to go to some personal examples of patent-skilled people. And this is the ultimate example of Albert Einstein. From age 23 to 30, what did he do? He worked as an examiner in the Swiss Patent Office in Bern, Switzerland. His job was to understand and deal with the definitions of inventions and discoveries. At the age of 26, while still employed as a patent examiner, Einstein made 3 of his greatest contributions to scientific knowledge. I suppose a lot of you might think about Albert Einstein as surely coming up with these ideas. He was in a university setting and getting his PhD or something. No, he wasn't. He was a patent examiner. He was studying patent claims. He was forced to refine his thinking about fundamental concepts. And that's done exquisitely by understanding patent claims. It was not until Einstein was 30 years old that he held any academic position. Let's look at Chester Carlson. He was laid off as a research engineer at Bell Labs. He worked briefly for a patent attorney and then got his law degree and became a full-time patent attorney. He became skilled in understanding patent claims in the invention process. When he was 31, he filed the first patent application on the Xerox machine. Before his death in 1968, he had given over $100 million of his resulting wealth to charity. The thinking that he used to come up with the Xerox machine was deeply impacted by his skills in writing patent claims. One of the things about understanding and defining new inventions that separates it from most everything else that you do is that for new inventions, you cannot look up the answer of what it is anywhere else because it's new. The three steps that you have to take to define a new invention is first, you have to do the search to know what the prior designs are, and then you find the factors that distinguish the invention from prior designs. And then you work to determine an appropriate level of abstraction for the terms used in the definitions of the inventions. And then you create an invention definition from the abstractions determined. Now, by way of abstractions, we'll have an example here of this hinge that's shown in the PowerPoint in the upper right-hand corner. Now, what is that? How do you define that? And what level of abstraction do you want to use to define that? Well, you could use a very narrow level of abstraction. It's a Schlage model 1011F large door hinge with a 3.5-inch radius corner on each of the four corners. You could use a not quite so narrow, but still narrow definition. You could say a brass hinge having two plates connected with a hinge pin and 3 holes in each plate. That's still pretty narrow. You could define that invention as a metal hinge having 2 plates, each having at least 1 mounting hole. That's a little bit more abstract, but still relatively concrete. You could have a very broad invention definition, which would be means permitting pivoting of a first member with respect to a second member with 1 degree of freedom. That would be a pretty broad definition, but a much broader definition would be to define it as mass. And the discipline of going through to try to define inventions with different levels of abstractions and working with each one and seeing which one is the best and how far you can go in abstracting before you start reading on the prior art, which obviously mass does, is a part of the trick and the talent that goes into patent claim analysis. For engineers and scientists, distilling an invention to clearly defined terms, words, clarifies further thinking about the invention, enhancing further innovation and discovery in the process. Invention definitions are often at the core of patent licensing, and so if you understand invention definitions, you can do a much better job in licensing to know how much you can justify in royalty rates, as well as to the nature and terms that you have associated with the licensing, because you understand what the design alternatives are, as well as which would avoid the payment of the royalty, as well as what would be encompassed by the payment of the royalty. In patent infringement lawsuits, one not only needs to understand the issued patent claims, but one also needs to carefully reassess whether a better invention definition than was incorporated into those claims, whether those better definitions should be woven into arguments to aid in the persuasive process. That's a routine step that we do when we have patent infringement cases, is we try to redefine the invention, knowing how much more you know at the later point of a lawsuit than you knew when the case was being originally filed. You define it a little bit differently and a little bit more precisely for the benefit of the judge and the jury. To better understand the process, the most helpful approach is to define simple mechanical inventions, assuming a specific primitive collection of prior art. In the same way as when you learn physics, you have massless strings and frictionless pulleys that enables you to understand the principles of physics. In order to understand the principles of claim drafting, we have a simplified set of facts so that you understand more clearly what the concepts are that are involved. Now, let's pretend that there's no prior art of any type and that this red seat chair was just invented, the first invention in the world. And there it is. Now, how are we going to claim it? We might initially define the invention as a chair having a seat with 4 legs and a back attached to the seat. Yet a person later making a backless 3-legged stool would not have their product covered by that definition, and you normally want to get as broad a coverage as you can on an invention. So we didn't do a very good job defining the invention as a seat with 4 legs and a back attached to it. That described the chair just fine, but it didn't give you an invention definition that was broad. If instead we defined the invention as a seat with 1 leg attached to it, we would have a definition which would be much broader and much more suitable to our hypothetical inventor of the chair. Our invention definition does not need to include all of the parts of the chair. And that's important to the thinking process. You're not really trying to describe what it is that's there when you define an invention. You're trying to describe something that is very broad in concept, that doesn't describe the prior art, but does describe everything later that would gain value from what is learned from the invention. Now let's change our hypothetical and assume that the only prior art is the backless 3-legged stool. We're now making that 3-legged stool part of the prior art. Then our initial definition looks more reasonable. A chair having a seat with 4 legs and a back, because that doesn't describe the prior art, and so that claim might be valid. Yet that definition still is unnecessarily restrictive. It contains 2 items not found in the prior art, a back and an extra leg. Eliminating either one of those restrictions would make the claim broader and would still avoid reading on the prior art. So we have 2 examples of better definitions. Combination having a seat with 4 legs attached to the seat. That's a good definition. It avoids the prior art of the 3-legged stool. Or we could have a combination of a seat with a back coupled to the seat. And that would be infringed by a bench with no legs that would have a back. And so that would be a pretty broad definition for the chair, given that the 3-legged stool is our only prior art. Now, if you really wanted to get broad, you could also say the chair is defined as an invention as a red seat or a red substance. Final comments. The preceding samples of patent claims hopefully will give some insight into the analytical process in writing invention definitions. And our presumption is that product designs can be improved in innovative ways for those having a good understanding of how to define inventions. Thank you.
Thanks, John. So we'll wait to take questions. All of you?
Yes.
I had a question about foreign patents.
Yes.
So if you have patent in America and you don't have it overseas, nobody can stop anybody overseas to make this patent there, right? Even if you have it here.
That is the question is whether or not if you have a patent overseas, does that have any impact on, if you have a patent only in the U.S., does that have any impact on people making it overseas? It has no impact on people making it overseas unless they try to import it into the U.S.
Once they start to import it, then...
Once they start to import, they then infringe the moment that they import. And you can stop the importation, but you cannot stop them from making it overseas if you have no overseas patents. If you only have a U.S. patent, you have no jurisdiction, no power to do anything in countries where you have no patent.
Is
Yes?
there any way in which you can have a...
Speak into the microphone. Thanks.
Is there any way in which you have a universal patent in just one process, or always you have to apply for the patent in each country you would like to have the patent?
There is something called the Patent Cooperation Treaty that allows you to have one filing for most all industrialized countries. And so you can get one search and one examination, and then that legally is split up into separate patents as a result of that one filing. Didn't used to be that way, but now the Patent Cooperation Treaty lets you do that. There's also a European patent that is specific to Europe that is even better if you're trying to get European coverage in a lot of countries in Europe. So there are ways that under treaties where you can sort of accomplish that. It's imperfect, but it's much better than it was. Yes?
You were talking about royalties over time being worth more. How did that happen? Like, is that initially debated in the beginning of the process, or every year it's looked at over again and determined?
Normally you have an agreement for the life of the patent, and sometimes an inventor who has a patent really wants to incentivize a company to get into a business. And they'll say, for the first 3 years, the royalty will only be half as much, because I know you're going to have to incur all these capital expenditures up front. You're going to take a risk getting it to the market. But once it's established, then I want the royalty to revert to a more normal rate. So that's how you can start out lower and go higher. Sometimes it works the other way around, too, but that's the typical case that we've done. Yes?
I know there are different kind of ways to go about getting a patent, whether it's a patent attorney, or I don't remember if it's
Right.
Could you maybe give some background on different ways and I guess maybe some pros and cons of those?
It is a very difficult job to find a patent attorney who will do a good job for you, because you have very little ability to judge quality. And so whether it's an agent or an attorney, some of it depends upon the nature of the invention. Sometimes you really don't care about getting a good patent. You just want to tell people, I've got a patent and this is a patented product, and you get the patent more for marketing purposes. In that case, you go cheap, low cost. You don't really care much about anything. You just get a patent. Other times, you've got a really good idea for which the wording of the patent claim is going to be critical long term, and you really want to have a good job done. And it's really difficult. There's a wide range of talent in patent attorneys and agents, and there's a wide range in costs per hour or whatever for patent attorneys and agents, and so it's really hard to pick. Some that charge a lot of money aren't very good, and some that don't charge much money are pretty good, but that doesn't last for long. They then start making more money. So it isn't necessarily the billing rate that they charge. You can look at patents that have issued and sort of get a sense that they've written. You can search on the Patent Office website and by attorney or by law firm, and you can look at them and try to make some judgment there. But that's really hard because you don't really know what the prior art was that they were working against, and what the budget was, or what other constraints that there were in that particular case. Just talk with different people and make a judgment is about the best you can do. And the more you understand about what the goals are in defining inventions broadly, the better you can make that judgment and make an assessment as to whether the person you hire is doing a good job or not.
I have a comment there. I mean, when John first came on board here, I took his class maybe 1.5 times or 2 times, and it's a fairly deep subject matter, and helped me very early in my career to discuss my research-based inventions with attorneys, because I had a better understanding of what the claims mean and so on. And I was able to judge, as John said, whether they were doing a good job or not. But that said, the attorneys that have good experience bring a unique set of skills and understanding that it's going to be very hard for you to get there very quickly. So it's good to take John's class in general. I would highly recommend anybody who's interested in design to take it at some point.
It's fun. The students seem to enjoy it. So it's only a 1 credit hour course, so it's really not much of a burden as well.
I should also add that course rating by the students is almost a perfect score. Everybody likes it.
Yeah, I do some things different. And being an adjunct professor, I'm not quite so constrained by the regular rules of Purdue. And a little more adaptive. And one of the things that I do in the course that is a significant burden on me, but the students seem to like it, is the major homework project is due in about the middle of the semester. Is to have them pick a topic of interest to them and find a patent related to that topic and analyze that patent. And because each person has their own areas of interest that are unique from other people, they seem to like the idea that they're actually working in an area of their choice and in a technology of their choice and analyzing a patent of interest to them. And then I have to grade all those different patents in all these different areas of technology and understand each patent and how it's supposed to. So it's a bit of a burden on me, but the students seem to enjoy being able to pick a subject that they like. And the other thing about the course that is quite unique is that it's front-loaded in work, so that when you get towards the end of the semester, when everything sort of piles on you, my course is essentially not a burden. And that people appreciate that as well. But
yeah. What's the difference between a patent attorney and a patent agent?
A patent attorney has gone to law school and passed a state bar examination, so that he's entitled to do licensing matters and court matters. A patent agent has only been approved to write patent applications as a career path. He's not been approved to do licensing or litigation. And so if all you want is a patent to be written, that's fine, but we don't have patent agents in our firm, because most things, when you write the patent application and you want to license it, you want somebody who is up to speed, who has knowledge about your specific case, who actually wrote your patent application, to become involved in the licensing of that or in the litigation of that or whatever else may flow from that. And so that's why we encourage people to use patent attorneys rather than patent agents. I was a patent agent first because I took the patent agent's exam in law school, but it was for like a 9-month period as a patent agent. Then I passed the bar and became a patent attorney. My younger son is a patent agent, and he works for a company called Intellectual Ventures in values patents for a living, and controls the buying and selling of patents and prices them and that sort of thing. He's planning to go to law school this fall and become a patent attorney as well. But so it's a fine career path, particularly for people who don't really want to go to law school but who like working in patents. But for the inventor, most inventors would like to have the person that wrote the patent, who's become intimately familiar with the patent, to be the one who handles the licensing matters. And so it's a little tough to stick with a patent agent for very long, because you normally want to do something other than just get the patent. Yeah.
Just have a comment. There are a surprisingly large number of Purdue engineering students that become patent attorneys. They go to law school and take that alternate career path. I've seen that happen quite often. Maybe John has some comments, but there seems to be fairly interesting set of attributes that they have coming out of here that makes them go that alternate path.
It's a pretty good career path. You find, right now there's huge numbers of people coming out of law school that can't get jobs. It's just massive numbers of people. And the problem with a lot of people is they go through college and they get out of college and they find that they can't get jobs that pay much of anything unless they happen to be in engineering or science or some valuable field, or nursing or accounting. But for the most part, people with the liberal arts backgrounds or history or political science or whatever, what are they going to do? They want to make a lot of money. What choices do they have? Well, they go to law school. And law school is a very efficient way to get a degree. Law schools can make a lot of money with a lot of students and very few professors, and so they churn out huge numbers of lawyers, and so there's a massive number of unemployed lawyers or lawyers looking for other career jobs. And in the practice of law, competence matters more so than in many professions. If you are really a good lawyer, you can make huge amounts of money and have a fun life and accomplish a lot in society. If you are a mediocre or below normal lawyer, you don't last long. The system sorts you out pretty effectively. I mean, we have in the schools now this goal to make sure everybody graduates and whatever else, and push people out of the real world. But the real world doesn't care. The real world sorts it out very effectively. And so you're up against all these other people getting a law degree, and you get out in the real world, and there's real competition, and there's a quality sort that happens, and so. I analogize the practice of law to acting. There's a lot of people who want to be actors and actresses. And you look at the salaries of actors and actresses, and we're learning that some people get $2 million an episode for some of the things that they do, and other people can't get minimum wage to do their acting. And the law sorts in a similar fashion. It's not like dentists and other things, but what turns out is that people who have engineering degrees who go to law school have developed really good disciplines and analysis and work ethic. And we hired the #1 graduate from IU PUI Law School in Indianapolis, where our firm is located, 3 years in a row, top student. Each time they were technically trained before they went to law school. And the technical background is an extraordinarily powerful background for the kind of skills that you need in law school. If you have any modicum of ability to write with decent grammar, you'll do very well in law school compared to the people who have their political science or history or English or whatever degrees. And so you tend to come to the top in the law school process if you have an engineering background, and then it translates into good job placement and successful careers. Patent lawyers make more money than other lawyers generally, not universally, but generally. And our firm is composed exclusively of patent lawyers. We don't have the other kind of lawyers in our firm. All of our attorneys have an engineering or science degree in our firm, and we do really well. So that's yeah.
What was the name of the firm? So.
It's Woodard, M. Hart, Moriarty, McNett, and Henry. Yeah, we have 30 patent lawyers in our firm. Yeah.
Kind of in general, what would you say the difference is between like engineering school and law school? Or are there a lot of similarities?
The law school, the fact that their law school's grades are based entirely on your final examination. And you go through a semester and having no clue how you're doing. You have your final exam week, and you take all your final exams in 3 days or 4 days, and that's your grade for the semester. Final exams here at Purdue sort of emulate that a bit compared to what some schools have. That's the comparison that would show a differentiation. I found law school to be fascinating, and I didn't expect that going into law school. I thought, well, I'll just learn the rules and get out. But I really found it to be fascinating and enjoyable, and the training in engineering, the discipline that you have, translates well. You would think not, because this is all about laws and whatever else, but that's not really what law school is about. Law school is about the analytical process and being able to analyze things, and the engineers are trained innately in being able to do that well. So it's a good career path. Even now, though, and I guess any career path now has the problem with when you graduate, can you get a job? So it isn't necessarily helped or hurt by whether you go to law school. Did that answer your question? Yeah.
Any other
It's
questions?
a lot of reading. A lot of reading in law school. You have to read a lot of cases and outline them.
I have a quick question. So,
if a company infringes on a particular patent, but their process is deemed as a trade secret, how do you deal with that? Because it's protected in its own right. They can't disclose the fact of what that process is. They
lose their business, but another company is
accusing them of infringing a particular patent.
Okay. Well, you can infringe a patent. It depends on what the patent. Depends upon what the patent covers as to whether you even know that they're infringing. Some chemical processes are done in secret, and they will always be done. Nobody can ever figure out what's a client now that's been using a process for 30 years. That a couple of clients that have been using processes that are secret, and then nobody would ever know whether they were infringing or not. But if you can tell they're infringing through some way, the fact that they have trade secrets associated with the process is of no consequence. The courts will let the attorneys find out what those secrets are for purposes of resolving the lawsuit. And the court process is done in secret. You can have court processes even with national security issues, where there are government defense secrets, which all the proceedings are closed to the public, and the judge and the parties on both sides get to know what the facts are. Sometimes the parties don't even know what the facts are, and only the lawyers get to know. But the secrets can be accessed through judicial process universally. It's not a problem in the United States. Other countries have different rules that make it more difficult. But in the United States, the premise is that everybody gets to find out what the other side knows. And other than attorney-client privileged information, it's all accessible in the legal process. And that's why litigation is so expensive in the United States, and that's why the quality of justice is so high in the United States. We just pay a whole lot of money for finding out what the truth really is, and more so than any other country. Yeah.
Does your firm, when a client comes to you, do you first research on what they're trying to do before you take them as a client, or do you usually I defend them either way, whether lose or not?
Oh, that's an interesting question. I don't mind defending somebody who is infringing a valid patent. I mean, the goal is to see if you can get a deal worked out where he gets a license or he changes his design. I mean, there's all kinds of ways that you can help people who are in the wrong straighten up and do right. That's when they need counsel the most. So that's not a problem. We don't get involved in criminal matters, so I don't have the issue of whether he's doing something that violates some state law and would be sent to prison. I just don't get involved in those kinds of things. But whether the person's going to win or lose is somewhat secondary to whether or not they need good representation and need good advice as to what they ought to be doing, whether they should change quickly or how much money they have to pay. Can you make it a little bit less money than they were thinking they were going to have to pay, or whatever. So it to me, it doesn't really matter which side I'm on. It's only if you have an unreasonable lawyer on one side or the other, or an unreasonable party on one side or the other, that matters really go through litigation and get really expensive and difficult. I've had a fair number of trials of patent infringement matters, and I have yet to lose one. And I've represented both plaintiffs and defendants, and patent owners and patent alleged infringers. And so if you settle the cases where your position isn't good, and if you take the cases on through where your position is right and the other side's being unreasonable, and you go to trial. You can even have a defendant who's reasonable and the plaintiff who's unreasonable, and the plaintiff may win, but he may be asking for $100 million and the case is only worth $2 million. So then you go to trial, and if in theory you lose for $2 million, that can be viewed as a win, because justice was done, because that's how much he should have paid instead of the $100 million the plaintiff was wanting. That's all how you look at it. You want a fair result, whichever side you're on. And you want to advocate for your client to participate in a fair deal, whichever side you're on. Whether you're on the plaintiff side or the defendant side, doesn't matter.
That's a good question. I mean, John, you have been on both sides of Purdue, actually, at some point.
Yeah.
With the Cook biotech case. And the class is going to probably go for a tour for Cook, but I just use that example as an interesting one.
Yeah, but it really doesn't matter. Your goal is to have justice done and to make sure each person thinks they've got a good understanding of what the rules are, what the law is, and how they can, if they've done wrong, how they can make it right in a fair way and not being taken advantage of. Just because you do something wrong doesn't mean you owe your entire life savings and your firstborn to give to the other side. I mean, everything has to be quantified and determined. So that's sort of how it works out.
So we have time for maybe one or two more questions. Go ahead.
It seems like if you are an engineer for a larger company, if you help invent something, I don't know how this works exactly, but it seems like that company then owns the patent, and you don't really get a slice of it. Is that kind of how it works? Or?
It works however you've written an agreement. If you are hired to invent for any company of any size, and you come up with the invention for which you were hired, the company owns that invention, unless you have an agreement to the contrary. That's the way it works. If you start your own company, it's yours. If your company has a policy where they give bonuses or rewards or percentages, then you can pick those companies and work for them and get some other deal. Most companies require an assignment of inventions. I think that's the best rule. I don't think it's a good idea to have inventors in a company getting percentages of inventions that they make, because that distorts their judgment as to what to recommend for the company's products. They will try to design in features that they get a royalty on, even if they're not optimum for the country. You get a conflict of interest problem when you do that. I think the ideal compensation structure is for companies that have really good inventors to pay them a lot of salary and not link it to the particular inventions directly, so that they stay there and continue to invent and make a lot of money, but not to have it as a percentage of the sales of products in a direct fashion, because that, I think, is a corrupting of the relationship and of the loyalty to the company rather than your own percentage interest. There are a lot of different philosophies on that, but I think that's really the one that tends to work best. I think in Germany there are rules that require inventors to get a percentage, but the United States doesn't have any such rule, and I don't know how well that works in Germany.
So thank you very much, John.
Okay.
So we appreciate your time.